Welcome to the lesson on the age of criminal responsibility. As usual, the learning materials for this topic can be found in the description below the video, in order of appearance. In this session, we explore the current age of criminal responsibility in England and Wales, which remains set at 10 years old. Lord Ahmed's statement encapsulates the gravity of this position. The law treats children of 10 as capable of bearing full criminal responsibility for their actions. Understanding what this implies requires stepping beyond doctrinal criminal law and into a broader interdisciplinary analysis. At its core, the issue raises profound questions about how we conceptualize responsibility, maturity, and blameworthiness. The central concern is whether children at the age of 10 possess sufficient cognitive and moral development to grasp the meaning and consequences of their conduct in a way that meaningfully justifies holding them criminally accountable. This is not purely a legal inquiry. As Near Pride suggests, psychological research plays an unavoidable role, since any discussion of capacity and understanding must be rooted in realistic assessments of child development. The U.S. National Conference of State Legislatures broadly confirms that without that perspective, legal analysis risks operating in abstraction. There is also a distinctly theoretical dimension within criminal law itself. The concepts of fault, culpability, and responsibility must be examined closely. We must ask what it means for a child to be responsible in the criminal sense, and whether that responsibility can be meaningfully attributed to someone whose moral reasoning, impulse control, and appreciation of long-term consequences are still in formation. Closely tied to this is an inquiry into the purposes of the criminal justice system. As noted in a Penal Reform International's briefing, criminal law does not operate in a vacuum. Its rationales, whether grounded in punishment, deterrence, protection, or rehabilitation, shape how we treat young offenders. These questions carry particular weight in relation to children, because early exposure to the criminal justice system can have enduring effects on identity, opportunities, and social integration. Another crucial element is the international dimension. The Committee on the Rights of the Child, in its General Comment No. 10, has taken the view that a minimum age of criminal responsibility below 12 is not internationally acceptable. This is not merely an aspirational statement, it reflects a sustained international discourse on child rights and developmental appropriateness. The committee's position also highlights that England's threshold of 10 is out of step with prevailing international expectations. Indeed, Cipriani reminds us that the global median age is around 12, revealing a degree of convergence at a higher level than the English standard. This divergence requires careful scrutiny, especially as the United Kingdom is otherwise committed, at least in principle, to upholding its international obligations in the sphere of children's rights. A comparative perspective also proves useful. Similar debates have unfolded in other jurisdictions, such as Australia, where Gregor Herbers argues that significant attention, including by the Jesuit Social Services, has been paid to the developmental, social and policy arguments for raising the minimum age. These discussions mirror many of the concerns expressed about the English position, including the impact of early criminalization and the reliability of moral understanding in young children. The academic literature is noticeably critical of the current age threshold. Many scholars argue that 10 is too young an age at which to expose children to the punitive machinery of the criminal law. A central point repeatedly raised, including by Arthur, is the need to interrogate the assumption that a 10-year-old can genuinely appreciate the criminal wrongfulness of their conduct. Distinguishing between moral wrongness and criminal wrongness is not an intuitive process. A child may understand that an activity is wrong in a general sense, yet lack the deeper contextual appreciation that the criminal law expects adults to possess. This gap raises the possibility that the attribution of criminal culpability may be misplaced. Such concerns form the foundation of the position adopted in this lecture. Meanwhile, it is worth recalling Lord Dolakear's speech during the parliamentary debates of one of the many proposed, and failed, age of criminal responsibility bills. At 10 years old, the age of criminal responsibility in England, Wales and Northern Ireland is the lowest in Europe. In Ireland in 2006, the age was raised to 12, with exceptions for homicide, rape or aggravated sexual assault. In Scotland, children cannot be prosecuted below the age of 12. Outside the British Isles, the age of criminal responsibility is invariably higher. In France, Greece and Poland it is 13. In Germany, Spain, Italy, Austria, Belgium, Hungary, Bulgaria and Romania it is 14. In the rest of Europe, it ranges between 14 and 18. While the analysis will remain open to the competing arguments, the overarching view is that when psychological knowledge, criminological research, jurisprudential principles, international standards and comparative debates are examined collectively, they point in a consistent direction. The conclusion that emerges is that a minimum age of 10 is too low to satisfy the requirements of justice, proportionality and child welfare. The current English approach therefore warrants reconsideration if it is to reflect not only contemporary understanding of child development but also a criminal justice system committed to fairness and rehabilitation. Thank you for viewing this sample lecture and your interest in this topic. To explore matters of criminal justice in greater depth, please consult our dedicated video lectures. We hope that this lesson was helpful to you and are looking forward to seeing you again soon.